On the noes of 59 Part 1 as amended will stand part. We come now to the debate on clauses 5 to 41. So the question is that Part 2 stand part.
Thank you, Mr.
Minister Judith Collins.
Thank you, Mr. Chair. Mr. Chair, Part 2 of this bill contains a number of powers specifically for the police. One of the most contentious of these powers is examination orders. Examination orders are included as the police only power to reflect the need for the police to have similar powers to the Serious Fraud Office, as both agencies investigate very serious and complex offences. The powers in the bill were examined closely by the Justice and Electoral Committee, who made a number of recommendations ensuring rights and protections available to people were maintained. It is expected that privileges such as a journalist's right to protect their sources, legal privilege, religious privilege, medical privilege and privilege for informers will be considered by judges and issuing officers in determining whether an examination order should be made. This is consistent with the balancing of interests currently undertaken by judicial officers when issuing a search warrant on media premises or other premises where privileged information and material is likely to be found. Examination orders may only be made in the business context where there are reasonable grounds to suspect that an offence punishable by imprisonment for a term of 5 years or more is or will be committed. In the non-business context, the use of examination orders has been further restricted to reflect the special relationships at risk in this context. Examination orders in the non-business context may only be used when the offending in question is a serious or complex fraud offence punishable by imprisonment for a term of 7 years or more, or the offence is or will be committed wholly or partly by an organised criminal group. The application process further restricts the use of these powers, as examination orders may be applied for only by an inspector or more senior officer, and the making of the application must be approved by a Deputy Commissioner, Assistant Commissioner or the District Commander of Police. These restrictions ensure that this power will not be used on a regular basis. The protection offered under Section 68 of the Evidence Act 2006, where a journalist cannot be required to reveal their source except under restricted circumstances, is carried across to the Search and Surveillance Bill, as is the privilege against self-incrimination. Examination orders may only be issued by a judge who will consider rights, including freedom of expression, when assessing whether an examination order should be made. A journalist who is presented with a production order or an examination order can refuse to reveal their source by claiming this protection. Any person can refuse to answer a question or produce documents if it would incriminate them. If the police dispute any claim of privilege, they may apply to a judge for a determination of its validity. A judge will only require a source's name to be provided if the name itself is required to assess whether the claim is valid. Similarly, the judge will only require this evidence if it is necessary in order for them to assess whether self-incrimination is reasonably likely. If the judge upholds a claim of privilege, the privileged material, such as the source or name, is inadmissible in any proceedings. The examination order powers have been subject to careful consideration by the Justice and Electoral Committee and to robust controls governing their use. This provides protection to those subject to these orders and restricts utilisation of the power to offending that warrants their use. Examination orders are also subject to a strict reporting regime in order to track the use and effectiveness of the power.
Honourable David Parker.
Mr. Chairman, the irony